Thank you for being here. Good afternoon. Today I want to start by citing again Visa's paper, turning to animal agency in the law, or making reference to, for instance, Michel, who says that let's go beyond sentience. But I want to challenge a little those assumptions, or maybe not exactly, but this presentation is about existing recognitions of animal agency in the law. And maybe contrary to what is assumed in animal law, that the law doesn't recognize animal agency, today I want to show that indeed animal agency has been always present in the law, even much more before than sentience. So this presentation has the following aims. First, demonstrate that the law already recognizes animal agency, that those recognitions did not improve animals' legal situation, and that for improving animal situation by recognitions of agency, we need to apply a sentience-based approach to animal agency in the law. So my first point is, it is possible agency without sentience, and I think one person asked today in the Q&A that question. And my answer is that yes. Maybe I'm wrong. I would love to discuss this after. But my question is that it is possible because sentience and agency are totally different concepts. Sentience is defined as the subjective experience of suffering and enjoyment. And indeed, when we talk about sentience, we talk that sentience should be the base for moral consideration, even preceding agential capacities such as rationality or planning, etc. On the other side, and also it is important to say that for being considered a sentient being, you don't need to prove that you are an agent. On the other side, agency, a minimum conception of agency, is the capacity to act, and to act is to generate behavior according with goals. And of course that animals, this applies to animals, but also this will apply to an autonomous vehicle that is going around the city, moved by its own makeup in a real-time planning. So for that reason, I consider that for being an agent, one does not need to be a sentient being. And this explains why in regimes, in very ancient regimes, where animals were mere property, mere objects, we still can find animal agency recognitions. First, we will see that the law already recognizes animals as complex autonomous agents. An autonomous agent is an agent that can act in its own behalf. The autonomous agent goes around the environment, making influence in the environment and not merely be pushed around. So if I am a unicellular being and the only way I can move, or I move, is according to the temperature or the pH of the water, I don't count as an agent. On the contrary, an autonomous agent has control and has also the capacity to initiate behavior, to control behavior. So in the law, we know that animals have always recognized as semoviente in Spanish, or things that can move by themselves. But this recognition of animals that can move by themselves have two purposes. Determination of animal ownership. For instance, in Roman law, a wild animal that escapes from his owner is no longer property. And that's from even so many centuries ago in Roman law. But also the other purpose for the recognition of animals as sentient beings is damages caused by animals. As Eva explained, the owner, for instance, Peruvian civil code says that the owner of an animal or the person who cares for it must repair the damages the animal causes. But this designation of animals as things that can move by themselves, our autonomous beings, is not the whole spectrum that I can see in these recognitions. I argue that with the recognition of animals as things that move by themselves, the law is recognizing that animals do not only engage in behaviors like a sunflower that rotates around the sun. There is something special about animal agency or animal movements that made them to deserve their own category. So I argue that the law recognizes that animals can act beyond their immediate needs. For instance, it's not enough for an animal to eat or to have water, etc. But rather, animals engage in goal-oriented behavioral sequences. For instance, when a cow wants to eat, the cow will not only go directly to the grass and begin to eat, but rather cows will engage in exploration, animals engage in fighting, etc. And indeed, the historical origin of the English common law doctrine of strict liability for harm caused by animals was applied specifically for livestock causing damages when trespassing on someone else's property. And in this book, the authors say that the owner of the animal, being aware of the natural tendencies to roam, should keep the animal under control. And these natural tendencies to roam, under current knowledge, we can ascribe to a natural tendency to roam obeys to inquisitive exploration. So animals enjoy looking for new places, enjoy looking for new adventures, new subjects to engage with, etc. A second recognition of animals that I found in the law is that the law already recognizes animals as agents with social and dangerous dispositions. And dispositions or tendencies are very important for philosophy of action. Tendencies or dispositions are considered inclinations of the subject or urgencies to behave in a specific way. And normally they are ascribed using the word can. For instance, a circus lion can attack the public. So in Roman law, we will find that domesticated or tame animals were considered res mancipi, and this characterization obeys to the ability to be able to control. But also, domesticated animals were recognized, this animus revertendi that Eva mentioned, that is referred to the tendency of the animal to come back. Also, we will find examples of 19th century cases where the judges recognized that animals can be mischievous. Also, in the US common law, wild animals are, the rule is that wild animals always will be presumed to have vicious character. They are savage, ambitious by nature, they have ferocity, etc. On the contrary, domesticated animals are presumed to be social, companionable, or harmless. The presumption is that these animals will never attack a person. So, for instance, in this case, Drake versus Dean, because the great majority of dogs are harmless, the possession of characteristics dangerous to mankind is properly regarded as a normal to them. So you have to demonstrate that the owner knew that the animal was dangerous to be able to recover for damages. But also, I found case law that recognizes that animals could be accustomed can have joyful behaviors. For instance, this case, Drake versus Dean mentions, one who keeps a large dog that he knows to be accustomed for found violently, often children and adults, is liable for the harm done by its dangerous playfulness or over-demonstrative affection. So, the recognition of animals' dispositions or tendencies, from a point of view, is also a recognition that animals have emotions. because specific dispositions are brought about by emotions according to some authors. The authors you can read there, Fontaine, explain that the basic emotions that all theories of emotions recognize, joy, fear, anger, and sadness, are hypothesized to trigger specific actions. Joy will trigger approaching, moving towards an object. Fear will move towards fleeing, anger towards aggression, and sadness towards apathy. So therefore, when we recognize animal tendencies, probably also we have to recognize that they have emotions behind. Also, the law already recognizes animals as agents who act for reasons. For instance, I found some examples of civil codes that recognize that animals can act by provocation. The Civil Code of Mexico says, if the animal that caused the damage was provoked by a third party, the responsibility lies with the third party and not with the owner of the animal, because of course, the third party provoked the animal. Also, the Oklahoma statute says that the owner of any dog shall be liable for damages when the dog, without provocation, bites or injures a person. And also very interesting for me is to find that the law already recognized that animals can act in self-defense. Peruvian law says the following: dogs will be sacrificed or euthanized when they have caused serious physical harm or death to people or animals. Paragraph 1 will not apply if the dog acts in defense of their owner, in their own defense, or in defense of their offspring. So the recognition that animals act by provocation or in self-defense, from my point of view, is also recognition that animals act for actions. For instance, there is a reason why a dog attacks a person. Reasons behind actions are not referred to rationality, but action reasons are always hypothesized to have mental states behind, such as desires and beliefs. The animal believes that barking or attacking the person will make the person go away. And reasons behind actions also imply that the actions performed are done on the basis of thought. So there is a cognitive element behind. And maybe this could be interesting also for Eva's evaluation about volitional, if something is volitional or not. But well, until here we have seen that from my point of view, the law already recognizes animals as autonomous agents with complex behaviors. Animals have dispositions that are brought about by emotions, and that animals act for reasons, that is, they have mental states behind their actions. But centuries of recognition of this animal agency didn't change anything for animals. So if you are you are interested in improving the situation of animals in the law, I propose a sentience-based approach to animal agency in the law. A sentience-based approach asks the following questions. The first one is, how does it feel to be the agent? We know that animals enjoy their agential experiences. They find pleasure not only in to eat or drink water or mate, but also there are a lot of materials that demonstrate that animal exercises agential activities for joy, for pleasure. They enjoy to be rewarded when they do things correctly. They like exploration, they like challenges, etc. And the other question is, when you apply a sentience-based approach to animal agency, agency has a clear epistemic function. And you will ask questions such as, what is the information that one can obtain from animals' behavior? Why the agent acted as she did? For instance, why a dog comes back to his home? Or in Eva's example, why that monkey escaped from his owner to IKEA? So there is a recent case in the UK where the ex-husband claimed the pet custody of his dog. And what happened is that one day the husband took the dog from the family home to his house, arguing that he paid for the dog, but the dog escaped from the house and the dog came back to the family home. And that triggered the action of the ex-husband to take again the dog. So in the judgment, it says, it was clear that when the dog ran back to the family home after he had been taken by the husband, that the dog considered the family home to be a safe place and where he belonged. And the judge declared that the dog should stay in the family home. So this is the kind of approaches that we have to always keep in mind when dealing with animal agency. But my conclusions are, first, legal recognition of complex animal agency, as I demonstrated before, have existed for centuries, and they have a solid foundation in Roman law, in common law, and in civil law. And this is a powerful advantage that we have. And what we can do is to take such recognitions and complement them with current knowledge in science and philosophy of action, and always interpret these recognitions using a sentience-based approach. And finally, the question that we have to deal in animal law is not go beyond sentient, but attend agency from sentience. Thank you to the funding, my supervisor and the project, and thank you.